Hello, everyone. Thanks so much for joining. My name is Amr Badat. I'm the Southern States Director and Senior Advisor at Fair Fight. We really appreciate everyone joining this evening. We're really excited to have an awesome conversation at this Fair Fight together with two esteemed attorneys and individuals who I have a ton of respect for. Really excited to have this conversation. We'll give folks a couple of minutes to filter in. If folks want to go in the chat and type in where you're from, we'd love to see where we have folks representing from. Again, thank you so much to folks for joining this evening. We're really excited to have this conversation. All right, we got LA in the building, Los Angeles, Fort Wayne, Indiana, El Paso, Atlanta. Okay, we got people from all over the place. We got Massachusetts, Illinois, New York in the building. All right. Well, like I said at the outset, my name is Amr Badat. I am the Southern States Director and Senior Advisor at Fair Fight. We are really thrilled to have this conversation tonight for our monthly Fair Fight Together conversation. Today, we're going to be talking about the Supreme Court and the Constitution with two really awesome and insightful attorneys and leaders in our country. And so, we're really excited to have you all here from all over the country. I see Massachusetts, I see Georgia, Colorado, Blue Mountain Lake, New York. Hello, Martha. Really excited to have you all here. Um, and so, with that, why don't we go ahead and get started? Hello, everyone. Welcome. Thank you again for joining us this evening. My name is Amr Badat. I'm Fair Fight's Southern States Director and Senior Advisor. Fair Fight Action is a nationally recognized leader and Georgia-based nonprofit that fights for free and fair elections. We fight against voter suppression, we expose anti-voter policies, we work to protect and expand voting rights and engage individuals at a grassroots level. We also support pro-voter candidates and convene civic engagement organizations across the country, and particularly in the South, to ensure elections are free and fair because every voice and every vote matters. And tonight, we are thrilled to have you here with us for Fair Fight Together. Tonight's event is part of a regular series where we gather with our friends, our supporters, activists, and advocates all over the country who support an America by and for we the people. This evening's conversation will feature two incredible experts here to talk about a very important topic that I am sure is on the minds of many of you who are joining us tonight, and that is the Supreme Court and the Constitution. And so, with that, I will go ahead and introduce our distinguished guests. First, Janai Nelson is the President and Director Counsel of the Legal Defense Fund, the nation's premier civil rights law organization advancing racial justice and equality. Janai has spent nearly 3 decades fighting for racial justice as a renowned litigator and a prolific legal scholar with specific expertise in election law. And in October 2025, she exercised that expertise in the Supreme Court. Janai argued Louisiana versus Calais before the U.S. Supreme Court. And this landmark voting rights case aims to secure equitable congressional representation for Black voters in Louisiana and defend the constitutionality of the Voting Rights Act of 1965. A graduate of NYU and UCLA Law School, Janai's leadership has been recognized nationally, and she is the recipient of numerous awards, including the Route 100, the New York University Distinguished Alumni Award, the M. Ashley Dickerson Diversity Award from the National Association of Women Lawyers, and the Metropolitan Black Bar Association's Public Servant of the Year Award. And I also have the privilege of being able to say that Janai was my boss when I was at LDF. And so we're really thrilled to have you with us here, Janai.
I'm delighted to be here and so good to see you.
Good to see you. And then we also are joined by Madiba Dennie. Madiba is an attorney, columnist, and professor whose work focuses on fostering an equitable multiracial democracy. She is the author of The Originalism Trap: How Extremists Stole the Constitution and How We the People Can Take It Back. Madiba is the deputy editor and senior contributor at the critical legal commentary outlet Balls and Strikes, which I recommend everyone here subscribe to and read. It is really, really insightful writing and helps us understand where we are as a country. In her previous role as a counsel at the Brennan Center for Justice, Madiba provided legal and policy analysis regarding a range of democracy issues, including the census, the courts, and attempts to disempower communities of color. Her legal and political commentary has been featured in The Atlantic, The Washington Post, and more, and she has also taught at Western Washington University and NYU School of Law. She earned her law degree from Columbia Law School and her undergraduate degree from Princeton University, where she concentrated in politics and earned a certificate in African American Studies. Madiba, welcome. We are so thrilled to have you.
Thank you so much for having me.
All right. So, with all of that, why don't we get started? And I want to start with a question for you, Madiba, to do a little bit of table setting and helping us take stock of where we are in the country with the Constitution and with the courts. A common question that we hear a lot in the midst of this authoritarian moment in the United States is, are the courts going to save us? And we're joined by two amazing experts who will help us understand that. And so, Madiba, I want to turn first to you and ask you, where are we as a country with the Constitution, with the courts? Can you help us take stock of kind of the health of our Constitution and the health of the institution of the courts?
Sure. Yeah. I'm no medical doctor, but if I were to take a pulse on our democracy, I would say it's doing a little faint right now. That it has been better and could be better again. And I think that's really in a range of ways that we're seeing this sort of struggle and fragility of our democracy. And the court system is definitely a big part of that. While I think that federal district court judges have done a pretty decent job for the most part in, trying to hold the line against this authoritarian regime. By the time you hit the Supreme Court, you've seen a lot of accommodation, like a lot of facilitation of clearly lawless acts, and it's deeply disturbing. And that's something that we're seeing in this moment, sort of on overdrive. But that is also not at all to suggest that the court was doing a stellar job before that, because the Supreme Court's sort of attacks on the Voting Rights Act have been going back for years. And so I think it's a really sort of troubling time when we see the court simultaneously retreating from protecting our democracy and protecting the right to vote, while you have, an administration that's really going hard on trying to shrink that we the people that you mentioned at the outset of this conversation. And, we have legislatures, state legislatures, since federal legislatures not passing nothing, but state legislatures passing a bunch of laws restricting the right to vote in many places. And so when you have these conditions, it's so much more important to have courts that, uphold the law, that protect our constitutional rights, protect our rights under the Voting Rights Act. And that's something that we've been lacking, at the very least at the highest level.
Yeah, and so you mentioned Madiba, district courts and the Supreme Court and how things are playing out in different ways throughout the district courts and the appellate courts in the country. And then once they get to the Supreme Court, who knows what'll happen. Janai, I'm curious to hear from you as the leader of LDF, one of the premier litigating organizations in the entire country. How are you all thinking about litigation and its role in fighting back against the regime in today's circumstances? How do you all think about litigating at the district court level? How do you think about going up to the Supreme Court when you're filing a case?
Yeah, that's such a great question. For a long time, not just since 2016, or certainly not since just 2024, has LDF been very, very strategic and thoughtful about the cases that we litigate, because there has been an assault on civil rights for many decades now. And we're seeing the culmination of the neglect to recognize that threat for what it is. And that is an effort not only to undermine civil and human rights, but to undermine democracy as a whole. So we're very thoughtful about the litigation that we bring, because we have to navigate the court system the increasingly stacked federal judiciary in ways to ensure that we aren't serving up a case that isn't well grounded in a record that supports the claims that we bring, that is well developed, and really puts the best possible case and set of facts and legal arguments forward so that our chances of succeeding are that much greater and higher, even within courts that don't really want to follow precedent and that are increasingly judicial activist courts. And I include, frankly, the Supreme Court in that. That said, LDF uses a lot of different tools. We use litigation, we use policy, we use research, we use organizing and strategic narrative to advance racial justice. But we were founded as a litigation shop. Litigation is certainly one of our most formidable tools. It remains a critical bulwark against some of the worst abuses of the Trump regime. I think right now there are over 700 cases challenging Trump and his administration in some way, shape, or form. And at LDF, we've been fighting back since day one, using all the tools that I just mentioned, but especially using the courts to challenge all the efforts that we're experiencing to, minimize and ultimately diminish our civil rights. We, since in the second Trump administration, have filed more lawsuits in this short period of time than we did the entire first Trump administration. And I think that's an indicator of how much the threats have metastasized, how emboldened this Trump 2 regime is, and frankly, how reckless they've been with the law, and the idea that they will have a welcoming audience in some of our federal courts. So if we look at, some of the cases we filed, we've taken on attempts to interfere with our elections, to end birthright citizenship, which was just argued just a little over a week ago by our incredible counsel at the ACLU, Cecilia Wang. We've litigated around the termination of temporary protected status for our Haitian and Somali community members. We've challenged the efforts to dismantle diversity, equity, and inclusion, and to cut off funding to combat discrimination. So we are using litigation to attack these executive orders, not only on their face as blatantly unlawful and contrary to our Constitution and civil rights laws, but also as an abuse of executive authority. Attempting to rewrite the Constitution with a Sharpie from the Oval Office is
Literally.
literally, right? It's just patently unlawful. And the courts have responded, already in 6 of the cases we're litigating and many more that others, federal judges have issued orders that are blocking the administration's action. So the courts have really been doing formidable work to stop this broad assault on democracy. And I think that when we are strapped for time and resources, when it takes weeks to galvanize people to turn out in the streets, and that protest is incredibly important, litigation is the tool that can help stop certain harmful actions in their tracks before they have the negative impact that was intended. And while it is not a panacea, while it will take every possible strategy that we have at our disposal, litigation is still a central one and has the power to prevent, I think, some of the worst excesses of this administration. So not a whole answer, but certainly one of the most effective tools we have to slow harm, to hold the line, and to ensure that our Constitution still has force in people's lives.
Yeah, I think, one of the encouraging parts of the last year and a half has been witnessing the court system, particularly the lower courts, do the job and actually work to block, like you said, the worst excesses and the kind of emboldened actions of this administration. And so it is incredibly important, the kind of the tool that we have in litigation to be able to fight back against all of this. Madiba, I want to ask you, in your book, The Originalism Trap, you talk about this whole concept of originalism, which I would love for you to kind of expand on a little bit for our audience. And you talk about how the Supreme Court in particular has used this theory of interpretation to kind of arrive at certain outcomes that they want to arrive at in specific cases. And so would love to hear you talk a little bit about, what is originalism? What is the originalism trap that you talk about in your book? And then also kind of how the resort to originalism kind of shapes the Supreme Court as an institution. Should we consider it as a political institution, a legal institution, something in between? How does originalism factor into kind of that analysis of the Supreme Court as an institution?
Yeah, definitely. Well, I think that being a legal institution and being a political institution are not mutually exclusive. Even when the court is making what, one might argue is like, oh, that was a purely legal decision. Like, I didn't see any sort of like partisan influences happening in it or what have you. The outcome is, still going to affect our political choices, our political system. They're shaping our lives in a way that is directly related to our politics. So I think the court is sort of inherently political, and there's it. So in that way, but there's also, the sort of the question about how much is politics involved, as in, the justices like personal politics or their ideological leanings, and that's where I think originalism really comes into play. So originalism is the idea that the meaning of the Constitution is fixed in time. Frozen at the moment of enactment. And so we have to understand the Constitution or understand, various laws the way the public purportedly understood them back then when they were ratified. This used to be a fringe idea, but over the past few decades, it has really gained prominence and now has some, high profile believers and defenders of originalism sitting on the Supreme Court. And, originalists claim that this provides objectivity and neutrality. They say it takes the politics out because otherwise judges would be free to just sort of do whatever they want to do. Now, they neglect to mention that where this sort of idea arose, that like this was the only way that you can make decisions, was in response to the Supreme Court saying you can't segregate schools anymore. That was when it was like in reaction to that you got members of Congress put out the Southern Manifesto, also known as the Statement of Constitutional Principles, saying, whoa, 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 I don't think the founding fathers meant for states to not have the ability to segregate schools if they wanted. So like that's really where sort of originalism is like the outgrowth of that movement, and continues to be used to really roll back the winds of the civil rights movement, roll back the winds of Reconstruction itself, and try restore the idea of the original Constitution, the framers' Constitution, locking us in to this time period where much of the country was much worse off. And they can be flexible with this originalist standard, like sometimes if the history is actually good, if there's like a relevant civil rights history, they ignore that. They limit their historical inquiry to that which furthers the goals of basically the anti-democratic goals, to make a government by and for white conservatives, white wealthy conservatives, just like a very narrow subset of the population, basically. And you see some of this historical chicanery in some of the major voting rights cases. A more recent example, I guess, a few years ago in the Brnovich decision, Justice Alito debuted this new standard for deciding Section 2 cases under the Voting Rights Act. He said, "Oh, here are some guideposts that that courts should consider," and these guideposts have, they're not from the statute. They're not from like the legislative history. They're just solely from Justice Alito's imagination, as far as I could tell. And one of these guideposts that sort of jumped out at me was like, well, Section 2 of the Voting Rights Act was like amended in like the 80s, and so laws that were commonly in place in the 80s are sort of like presumptively fine. And it's just like, what? That doesn't actually make any sense. You just made that up. Like, why would it be the case that laws at this time were that Congress meant to preserve them when they were amending the Voting Rights Act and trying to, make it easier for people to vindicate their constitutional right to have, a vote to have elections free from racial discrimination. Like that doesn't actually make any sense, but he sort of just put in a historical standard that seemed convenient to him, that would, allow states to bring back all sorts of laws that we've drifted away from, that could disenfranchise people, could dilute people's political power. And you saw some similar historical messiness in the Shelby County decision, where the Supreme Court struck down the formula that the Voting Rights Act used, the pre-clearance formula, that like identified jurisdictions that would have to basically present their proposed changes in like voting policies and laws to DOJ or to like a three-judge panel to prove that they was legit and like not discriminatory because they had a history of racial discrimination. The court struck that formula down, said it was out of date, and said, "Oh, this infringes on, the really long-standing principle of equal sovereignty because it's like treating some states differently." That's not a long-standing principle. First of all, what he's alluding to is the equal footing doctrine. That's something else. And second of all, that equal footing doctrine only applied to the conditions on which states became like one of the United States, which like they entered the Union. It had nothing to do with laws affecting some states differently than other states. And third of all, even when you look at that equal footing doctrine, it wasn't applied consistently anyway, because some states did have different conditions imposed on them when they entered the Union, namely the former Confederate states when they were re-entering the United States. So he just did this sort of historical grab bag that allowed him to cut out the heart of the Voting Rights Act, blocking its like most innovative provision. And so these are just two examples that deal with the Voting Rights Act specifically, where the court just sort of did a historical amalgamation, just sort of picking and choosing historical tidbits that it liked and mashing them together in order to present the public with slop that it claims is a justification for eroding democracy, especially rights for communities of color. And so I think that, originalism broadly is really a ploy. It's a trap, as I've said, that it gives the justices this sort of veneer of neutrality. They get like the guise of impartiality, but really it's like the bias is baked in. You are like not taking into account like how good this history is, like whether or not they're actually doing a good job, at identifying the real history. And even if they are, then there's like the next question of should we be relying on that? Should we be taking away the power of all of us today to decide like what we think law should mean and how to govern ourselves? Is that not what a democratic society is supposed to do? So these are just, I'm gonna step back from my anti-originalist soapbox before I get to going. But these are a fraction of the ways in which originalism is an illegitimate model of constitutional interpretation.
Yeah, and I think we saw, the a little bit of that grab bag approach to history and historical interpretation going on in several cases this term. the mail ballot case, the RNC versus Watson case that came out of Mississippi. During the argument, we heard all sorts of different kind of emphases and focuses on different parts of history from both parties and all of the justices, and it just wasn't clear, how are the justices supposed to take into account this history that's not, it doesn't appear to be consistent in all regards. And so I think we saw the limits of that approach and kind of the politicization of how justices kind of focus on history in different ways based
Yeah.
on how they want to see a particular outcome in the decision.
I mean, it's a direct Clarence Thomas quote. I'm not actually exaggerating. That he said, "Not all history is created equal." So,
Yeah, that sounds like Justice Thomas. And so, Madiba, you mentioned the Voting Rights Act, and obviously, a key provision of the Voting Rights Act, Section 2, is currently being considered by the Supreme Court in Louisiana versus Calais. And Janai, you were arguing before the justices in October of last year in the Calais lawsuit, and I want to turn to you and ask you one kind of what was that like? What was it like arguing at the Supreme Court? How did it feel to kind of be in that moment, a historic moment, not only for the Voting Rights Act, but for our democracy as a whole? Would love to kind of hear what that experience was like.
Yeah, happy to share. It's a unique experience that far too few women and Black women in particular get a chance to experience. So happy to tell you a little bit about what that felt like. I really, though, have to just commend Madiba's work around originalism. It is so important that we unpack the hypocrisy that we see in our court system and particularly on the Supreme Court. And when I think about, some of the origins of where things began to veer from our trajectory of expanded rights, of really interpreting the 14th Amendment in particular and the Reconstruction Amendments, but especially the 14th Amendment as expansively as I think even an originalist interpretation of the 14th Amendment would support, was really what Madiba pointed out. It was in 1954, Brown versus Board of Education, when the 14th Amendment was used to strike down legal apartheid in this country. And even in that decision, there were arguments to suggest that the 14th Amendment could not apply to public education because Black people didn't have access to public education at the time that it was originally ratified. And so how could this principle possibly apply in this context? And it was clear to the court at that time that, of course, this principle of equal protection is something that is expansive, capacious, malleable. It's something that we rely on Congress to breathe life into and animate because there are specific provisions in our Reconstruction Amendments that invite Congress to enforce these principles through legislation. And so we've seen that in most of our civil rights legislation, and especially in the Voting Rights Act. The Voting Rights Act of 1965 is, the high watermark of Congress using the Constitution and its enforcement powers under the 14th Amendment to ensure that the right to vote was protected, because remember, the 14th Amendment has very specific protections about the right to vote, not just the 15th Amendment, but the 14th as well. It exacts penalties when states try to disenfranchise voters. But it also says we all have equal protection under the law. And that means that laws that are created that govern our right to vote and that potentially limit access to that right, if they aren't experienced on an equal basis, that very well may be a violation of the Equal Protection Clause. And so the Voting Rights Act of 1965 is a statute that has done such transformative work in this country. It has literally changed the complexion of leadership in this country and was once touted by our very US Supreme Court as being the crown jewel of civil rights legislation. Now, fast forward to last October, you would not have known that if you were in the courtroom where I had the privilege and honor of providing oral arguments on behalf of our clients. It was a scenario where we saw the court trading different methods of constitutional interpretation to suit whatever the particular belief system was of the justice. And that wasn't unique to Louisiana versus Calais. We also saw something similar in Trump versus Barbara, which is the birthright citizenship case that I mentioned, where originalism is relied upon only to the extent that it gets you the outcome you're looking for. Because if you look at just the original text of the 14th Amendment, there's no way that you could question whether, and this is the question that the court presented to us in Calais, whether being conscious of race in remedying a violation of a statute intended to make voting equal, whether that somehow violates the 14th and 15th Amendment. It's effectively asking that when you identify a harm created by race discrimination and you want to fix it, you can't consider race at all in how you fix it, which means you may not even know if you fixed the problem because you're not checking for race. You can't undo or unwind the problem because doing so requires you to pay attention to the race discrimination that happened in the first place. So it is wholly illogical. And to bring you into the courtroom, it was a real challenge to have to entertain a vision of the 14th Amendment and an assault on the Voting Rights Act with a straight face, particularly because those arguments were not just anathema to a credible interpretation of the Constitution, but they were anathema to the court's own precedent just 2 years before. So the precursor to Louisiana versus Calais was that the Legal Defense Fund also won a case out of Alabama on nearly identical facts. And I know you know this very well, Amir, nearly identical facts showing that there was racial discrimination in the congressional voting map in Alabama. And we were able to use that precedent to press a same claim in Louisiana. And the court was very clear that the Voting Rights Act was enforceable, that a remedy that corrected race discrimination did not violate the Constitution, right? That was sort of baked into the ruling in that case. And that decision was written by Chief Justice Roberts. So you can imagine what it felt like to stand within a few feet of the justices at the podium and try to convince them of the very words that they wrote in a decision just 2 years earlier, and to not just rely on that recent decision, but to talk about what was ultimately about 140 years of combined precedent that proved that Congress had the authority to create vast and expansive transformative legislation like the Voting Rights Act, and that its constitutionality had been challenged many times before and routinely upheld by the Supreme Court. So there was a little bit of a cognitive dissonance between talking to the court about its own words and what precedent says, and longstanding precedent in every possible way, including basic structuralist arguments like separation of powers, and to have to do that with a straight face. But I will also say that it was a true honor and it was a profound responsibility to stand there, not just as an attorney, but on behalf of communities whose voices have, too often been diminished in our democracy, and specifically Black voters in Louisiana who've been fighting for fair representation for years. And if we look at the facts of the case that I argued, the only political power that Black voters in Louisiana have enjoyed has been as a result of litigation. So back to your question about the power of litigation, litigation is what is delivering the possibility of democracy and the ability to amass political power and have a voice and agency in your future in places like Louisiana and across the South. But what really stayed with me was the weight of that history of knowing that this case, Louisiana versus Calais, sits within a long line of struggles to ensure that our democracy reflects all of its people. It wasn't lost on me that when Thurgood Marshall, who founded the Legal Defense Fund, was asked what case he was most proud of, he didn't point to Brown versus Board of Education that I just mentioned, which most people would assume he would because of its primacy in the canon of constitutional law. But he was fixated on the power of the right to vote. And so to be able to argue for voting rights, the protection of voting rights, the protection of democracy on behalf of our courageous clients, Dr. Press Robinson and Edgar Cage and Dr. Dorothy Nairn and Bishop Edwin Renee Soule and Dr. Alice Washington and Reverend Clee Ernest Lowe and Commissioner Devontae Lewis, all of these wonderful humans who put their lives on the line, gave their time and energy to advance voting rights for all of our protection. That is what girded me at that podium when I had to deal with some of the arguments that I thought were disingenuous and often offensive, frankly. But that's what we do as civil rights lawyers. That's our job. And I was very, very honored to be able to perform that task.
And I'll just say you performed that task incredibly well. The argument I thought was incredibly persuasive, and the thing that stands out to me about that day, apart from your amazing argument, is also um, the rally that happened outside during the argument and after the argument. There were hundreds of people who had come to DC from across the country. There were buses that came up from southern states, and people showing up and showing out, and many of the people who had participated in the litigation, who had participated in all of the advocacy for years to get the fair maps that Louisiana ultimately did adopt and are being challenged in Calais. They all showed up and really demonstrated the power that was, I think, so characteristic of that moment. And so that really stuck out with me. Madiba, would love to hear your thoughts on Calais, the argument, and also can you help us understand kind of the stakes here as well? Janai talked about how transformational the Voting Rights Act and Section 2 has been for our democracy. Can you help us understand what the stakes are, and not only kind of the practical stakes, but also the legal stakes? What happens, legally for other types of civil rights laws if the court decides that Section 2 should be weakened in some way?
Yeah. I wanna follow up on as well just so many excellent points that Janai raised. And I think as far as what are the stakes, I think I will quote Janai at oral argument. I remember I think one of the justices asked you that question saying, like what'll be the outcome without the if we get rid of this? And you just said like catastrophic, just one word, just simply it would be terrible. The Voting Rights Act has been transformative, as you said, in thinking about the ability of people of color to have a vote, the ability to have people of color in Congress, the ability to for Congress to pass legislation that responds to people of color's needs. Like all of these things were shaped by the Voting Rights Act, and I think I would argue that that's why the Voting Rights Act is in danger. Like it's the target is on its back, or has been on its back for all these years because of how successful it has been. Because it was actually, doing what Congress set out to do in enforcing the Constitution's guarantees and, building this multiracial democracy. And so opponents of multiracial democracy have always hated the Voting Rights Act. And so what we're seeing is that sort of like continued legacy of them trying to claw back those wins. There were so many great points you made. I wanted to highlight a few that like jumped out at me. One was how you framed this as the question that the court presented, and I think that's precisely right because LDF had already argued this case. And it was extraordinarily clear under the law as it is that that there, of course, you can consider race to remedy an injury on racial lines. Like that's just, again, that's just common sense. And it's not just common sense, it's also court precedent. And it was, yeah, very clear. And so, sort of confronted with that, it was just the court said, huh, okay, this is really clearly the law. Can we change the law? Let's ask a new question. Let's volunteer our own question, and ask the parties if they can address for us whether or not these remedies are constitutional, since that was not actually the argument before. And of course, the state recognized that as the assist it was, and said like, "Yep, you're right. This is actually not constitutional. I'm happy to make that argument." And yeah, so this was just like purely an invitation that the court extended. And you had also mentioned, Janai, about how you were seeing lots of embracing different types of constitutional interpretation, like no actual loyalty and no actual beliefs about what a legitimate interpretive method is. It was, something that was shifting to reach their to reach what could be their desired outcome. And that was something I found really glaring as well when listening to the oral arguments. To me, I was like, it sounds like the justices are sort of spinning a wheel and being like, could this be the
Hmm.
reason that we strike it down? Maybe this could be a reason to strike it down. Like I remember Alito was doing this is like an Alito classic of like, is it really racial discrimination if it's actually about like partisanship? And it just so happens that Black people vote for Democrats. So when you discriminate against Democrats, you discriminate against Black people. But discriminating against Democrats is fine. It was like what Alito's questions seemed to be saying to me. And then you had Kavanaugh doing similarly, like one of his go-to moves that like I've seen Kavanaugh make these kinds of questions repeatedly, whether it's in Voting Rights Act cases or affirmative action cases, being like, isn't there a time limit? Like, isn't racism over? Do we have to keep doing this? Like, shouldn't there be some sort of stop date for laws? And I'm like, why do only anti-discrimination laws have expiration dates? No other law is treated like milk. And yet, when it comes to laws designed to enforce the Constitution's guarantees of equality, suddenly the court is just like watching the clock, or sort of doing the kid in the backseat of the car. Are we there yet? Are we there yet? Like that's the extent of what Brett Kavanaugh has to offer as far as legal interpretation goes. Just kid in the backseat. I have to pee. Okay, is this car gonna stop? Let me out. That's it. And then you had Neil Gorsuch doing the more direct, is this actually the real racism? Like isn't it really racial discrimination to take race into account to solve a racial injury? And like you said, it's just insulting, it's offensive. And this again returns to the idea of the court had just said like all of this stuff and has said it for years. And so I feel like we saw this in a Voting Rights Act case and have seen it in so many cases recently where it's like litigants and lower court judges are basically begging the Supreme Court to have some self-respect and to actually follow through on the things it said, to treat the things it said as that are law as if they are in fact law, and not just upending it willy-nilly to satisfy their political leanings and urges at that moment. Yeah, I feel like we've seen that in so many cases. Like something that comes to mind is one of the cases challenging the removal powers of Trump over heads of executive agencies. And I remember there was like a lower court opinion that was very straight up like, the court has a direct precedent on this. They haven't overruled it. And so I'm going to apply it because that's just how this works. Like, until the court says otherwise, I'm supposed to apply this precedent. And so what you're doing is clearly illegal. So I'm going to grant this injunction. And then the Supreme Court just came in and lifted the injunction. And it's like, okay, so I guess you weren't supposed to listen to what the court said the law was. You were just supposed to divine what they might want the law to be instead. So that's this sort of world we live in right now, which I think really puts litigants and judges alike at a loss often because like there's no sort of predictability, there's no rules, there's no consistency, there's just power and want.
Yeah, and that Janae, I don't know if you want to jump in there, but one thing that Madiba mentioned was and stood out to me as well about the argument is Justice Gorsuch's kind of incessant questions to you, Janae, about isn't this intentional discrimination? And I could hear you kind of walking the tightrope there and be like, no, it's not intentional discrimination. That's not how we would describe it,
That's
but.
not what that means, Justice.
That's not what that is.
Oh yes,
Yeah.
oh yes. The restraint and careful response. No, absolutely. And we see this idea of so-called reverse discrimination just permeating the jurisprudence right now and the zeitgeist, right? This idea that any addressing of race discrimination is somehow a harm to the perpetrators, that they now get to be the aggrieved. And we really need to disrupt that narrative. It is so false. If you need my oppression for you to feel whole and equal and undisturbed, then we've got a problem, right? That is not equal protection. That is not a fair system or a fair society. And there's no reason for us to believe that recognizing the concept of race that has been weaponized against people of color in this country since its inception, that recognizing that fact and remedying it based on that construct that has governed our so-called multiracial democracy, that can't possibly also be perpetuating the discrimination. The actual aim is to undo that discrimination and to finally create an equal playing field. So, there was a lot of sparring and correcting of the record and perception. But, to say something really positive about that experience is just to never forget the incredible role of having people like, Justice Ketanji Brown Jackson and Justice Sotomayor and Justice Kagan provide the necessary intellect and honesty and integrity and fidelity to the Constitution in a way that I think exposes exactly what the project is for their colleagues, but also I think helps to maintain the integrity of that institution. I will say that was really in stark relief during that argument and in so many others that we see across the term, and just felt that was really important, lest we despair that everyone on that 9-person court has just completely lost their anchoring when it comes to how the law should be interpreted. There really is a robust debate and some sharp legal minds that are still holding on to what is the best of our legal jurisprudence and the best of our judicial system. And I mean, there's so much I could respond to what Madiba said about the ways in which the argument was so complex. But I just will say the one thing that is that's particularly jarring is this idea that we just want to run from the project of remedying racial discrimination that is in the blood of that is like blood in the soil of this country. And I think it is exactly why we have found ourselves in this place of authoritarianism, or a march toward it, a march toward in a liberal democracy, an electoral autocracy. Fill in how you want to describe this, but what it isn't is a legitimate multiracial democracy. And the reason that we find ourselves here is because no one wants to roll up their sleeves and do the real work of remedying past discrimination, of healing from that ignominious history, of charting a course forward that will prevent the inertia that brings us back to this Achilles heel of our democracy. And I'm hoping that in this moment, we will say, you know what? The answer is not to run from race, to call it radical, to say that we need to bring forth a more centrist, accommodating discourse about the problems of this country, but to really reckon with it once and for all, and to understand that we need firm, durable guardrails in place to ensure that we aren't constantly fighting this cycle of progress and retrogression, of the expansion of rights and then the slashing of them. That is the only way we are going to get through this, because it is always the vector of race, and especially anti-Black racism, that helps undo the democratic structures that are supposed to protect all of us and protect the security and safety and legitimacy of this country.
Yeah, that's so helpful, Janai, and it's a really helpful way of thinking about kind of charting the path forward. And I've heard you speak about, refounding our democracy, and I've heard, obviously, Madiba, you talk about inclusive constitutionalism and kind of how that can provide us a path forward out of the situation that we're in as a country right now. Madiba, can you talk a little bit more about inclusive constitutionalism and kind of how you describe it in the book?
Sure, I would love to. So the idea is, I think, really goes right along with what Janae was just saying about how we can't run away from race. I think we need to be running towards the Reconstruction and the time post the Civil War where the government really made a deliberate, concerted effort to expand the political process to really create a multiracial democracy and include the people who had been forced out. When you talk about the Reconstruction Amendment, so that's your 13th Amendment, which is constitutionalizing the prohibition on slavery, with the exception of as punishment for a crime. You have the 14th Amendment, which is where you get equal protection, due process, exclusion of insurrectionists from holding office again. It's just putting that out there. It's where you get the penalty clause, where electoral power is reduced if the district is discriminating. You get and more. The 14th, there's so many provisions within the 14th Amendment. That's just my Cliff Note summary. You have the 15th Amendment, which was, putting into the Constitution that there is should be no racial discrimination in your right to vote. So all of these finally, put into the Constitution said like what was a document that had allowed this racial hierarchy, this oppressive caste system to flourish. It did away with that. It rejected that and put in its place a document designed and intended to build a multiracial democracy. And so my argument is that whenever we're interpreting any part of the Constitution, we must be doing so with the goals of the Reconstruction in mind. We should be doing it through the lens of the Reconstruction Amendments, thinking about those transformative, liberatory, emancipatory goals. So whenever we're thinking about any part of the Constitution, we should be thinking, if we were taking the Reconstruction Amendment seriously, what would this actually mean? If we were for real about having a multiracial democracy, like what would this look like? What would that require of us? What would that require of the government? Since Congress is tasked with passing legislation to enforce these guarantees. So it would, I think, radically change the way we conceptualize what power the government has, and what power we have, and like what things that we are entitled to. And so, yeah, I think that it is I guess mistake is the wrong word, since that kind of implies an accident, but it is, but we should not, but yeah, it was a mistake, for lack of a better term at the moment, to embrace the originalist approach of basing our constitutional interpretation on a point in time, when in fact, The Reconstruction Amendments tell us to do the opposite. They do not want us to stay locked into that particular moment in time. They want us to go out and be better, to make a better democracy, to actually have like an egalitarian society that works for all of us. And so I think that it is incumbent on us to think about these like pro-racial justice, like anti-oppression goals in our legal interpretation. That has to be part of how we think about the law, and that's not just, you know, me being this like big-hearted lefty person. That's squarely grounded in the law as well.
Yeah, thanks so much for that, Madiba. And I think, in today's context, when we are consistently being bombarded with all of the problems, it is so incredibly helpful to hear about ways that we can move forward and solutions, like both of you have talked about today. And so we are running up against the time limit that we have, but I want to end just by asking both of you quickly, in these times of kind of consistent feelings of being overwhelmed, like I'm sure many people in our audience feel when turning on the news or looking at their phones and seeing what's going on in our country. Would love to hear from you both. Kind of, how do you keep from feeling overwhelmed, or what personally brings you joy in these moments? Janai, I'll start with you.
Sure. I mean, I alluded to it a little bit, and that is what I hope will happen on the other side of this, and what I think is being revealed in this moment, and that is that we have never really addressed a core question that has stood as a threat to our ability to truly grow into our our adulthood as a multiracial democracy. I mean, I call the Voting Rights Act the birth certificate of our democracy, because we really weren't one before 1965. And if we think about that, in the 250th anniversary of the signing of the Declaration of Independence and this commemoration of our country's origins, if we put those 60 years against the 250, we're still in the toddler phase, right? We still have a lot of growing to do, a lot of work to do, which also means that there's a lot we can do to train this country. There's still a lot we can do to create the type of adult that we would like to see manifest from all of the trials and tribulations that we're experiencing right now. And so right now, what's giving me hope are two places that are, 4,000 miles apart. One is Hungary, and the other is the state of Maryland. Hungary proving that a liberal democracy doesn't have to be a permanent state, no matter how we got there, no matter how entrenched it seems the authoritarian power is. And then the state of Maryland, which is a fantastic reminder that we, the people, still have agency, and that we can hold our elected officials to account and have them pass laws and protections that are in keeping with who we desire to be as a democracy. So just last night, at the literal 11th hour, the state of Maryland passed a state voting rights act, becoming the ninth state in this country to adopt its own voting rights act while the federal one is under attack. And this is something that LDF has been working on across the country. We are moving forward in other states. We introduced, I mean, we didn't introduce it, but we helped many of our colleagues introduce a voting rights act in the state of Louisiana, in the state of Alabama. There's one in New Jersey. I think I saw some New Jersey folks in the chat. Let's get on the governor of New Jersey to move that one forward. We have work to do on the state and local level, and we are getting it done. And that's what excites me. What is going to be on the other side of this if we remain true to the conviction of equal protection and due process and all of the constitutional ideals that we claim to believe in? We finally have an opportunity to live those out robustly through how we respond to this moment.
Thanks so much, Janai. And on the state VRAs, one of the most impressive things I think that we've seen, apart from Maryland passing its state VRA last night, five states in the South. You mentioned Louisiana, Alabama, Georgia, Florida,
Mhm.
Mississippi have introduced state VRAs this year. And I think that tells us exactly where the South is coming from right now. The South is ready to fight and ready to protect Black political power. And so I think that's one of the things that really encourages me as well. Madiba, tell us what brings you joy in this moment.
Yeah, I'm learning right now from you all about Maryland passing the Voting Rights Act last night. I hadn't heard that yet, so that's something giving me joy at this very moment. Um, I think I also get a lot of joy out of doing events like this, just like being in conversation and community with people and like having a space where I remember that there are all these other people who care. I think sometimes it can feel overwhelming when it's like this onslaught of bad. So to just yeah be in a space with dozens of people and know that like we are all interested in and fighting for this better world is like very reassuring for me and yeah helpful for me. I think I also get joy in looking back at historical fights and seeing, like whenever I'm getting too down, I can think like if they didn't stop fighting when things looked a lot darker, and they sometimes even won in these really hard conditions, then there's no reason that I shouldn't fight. There's no reason that I can't win. I can do the same thing. So I think that that's very helpful for me as well. And separately, I'll just say I get a lot of joy from Star Trek because I'm a big old nerd, and I like seeing my sci-fi, my post-capitalistic, my great future in space. Give me some of that. I can't wait.
We all need a little bit of Star Trek in our lives, I think is the message tonight. Well, thank you so much, Janai Madiba, for being with us tonight and for all of the incredible work that you are doing to protect and advance our democracy. Thank you so much to everyone who attended tonight. We had, I think at some point 110, 115 people attending tonight, and we really appreciate you taking your time out of your evening to listen and talk about these really important issues. We will continue this series, the Fair Fight Together series, next month. Keep an eye out for more details about additional events, and we have a lot of links in the chat to the various Substacks and newsletters and websites for all of our organizations. So please take a look at the chat, and thank you again. Really, really appreciate you. Have a great night, everyone.